Okay, thank you. Hello, everyone. I'd like to call this meeting to order. This is the Board of Chiropractic Examiners Continuing Education meeting. This meeting of the Board of Chiropractic Examiners Continuing Education Committee is being held by conference pursuant to the statutory provisions of Government Code Section 11133. The date is December 12th, 2023, and the time is 12:05. The board's paramount responsibility is to protect the health, welfare, and safety of the public through licensure, education, engagement, and enforcement in chiropractic care. Members of the public may address the committee during the public comment session. Public comments will also be taken on agenda items at the time the item is heard and prior to the committee taking any action on said items. Those who would like to provide public comment will be limited to 3 minutes, unless in the discretion of the committee, circumstances require a longer period. Members of the public will not be permitted to yield their allotted time to other members of the public to make comments. Individuals may appear before the committee to discuss items not on today's agenda. However, the committee may not discuss or take action on these items, except to decide whether to place the matter on the agenda of a future meeting. Please be aware that this meeting is being recorded. Please turn off or silence all cell phones. We will now take roll call. Dr. Adams, will you please take roll?
Yes. Dr. Paris.
Present.
Dr. Daniels.
Present.
Dr. Adams is present. We have a quorum.
Thank you, Dr. Adams. Moving to agenda item number 2, review and possible approval of January 24th, 2023 committee meeting minutes. Let me open this for discussion. Are there any questions, comments, any changes to the meeting minutes from the January 4th, 2023 meeting minutes?
I have none.
Thank you.
None.
Thank you.
I motion that we approve the minutes of the January 4th, 2023 Continuing Education Committee meeting.
I'll second.
Thank you. Motion and a second. Moderator, would you please open this agenda item for public comment?
This is the moderator, and at the direction of the committee, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Please, thank you. Okay. Dr. Adams, would you please call the roll for the vote on the motion?
Yes. Dr. Paris?
Yes.
Dr. Daniels?
Yes.
Dr. Adams is yes. The motion carries.
Thank you. Moving to agenda item number 3, update on the board's continuing education program. And I will turn it over to Ms. Walker to provide an update on the board's CE program.
Sure, thank you. So I'm going to cover a few items during my update today. I'm going to start with statistics on our continuing education programs. So within our meeting materials, we've provided some statistics on what we're seeing as far as provider applications and course applications during the first 4 months of this fiscal year. As of at the end of October, we had approved just around 350 course applications, which account for just a little bit over 1,500 hours of continuing education. Comparing that to the last fiscal year, we observed that in that fiscal year, we had approved about 8,900 hours. So what we're really measuring right now at the staff level is we are entering kind of the busy phase of reviewing the continuing education course applications. So we're going to be closely looking at the numbers of approvals from November through January to really assess what our end numbers is potentially going to look like for this fiscal year. With that 1,500 hours as of the first third of the year, we're pretty much on target with what we put in our budget estimations for the fiscal year. As the committee may recall, with the implementation of the new hour-based fee for continuing education courses, we did anticipate a bit of a drop in the number of applications received. So we're still right around that number of what we expected to receive, but we are keeping a very close eye on it, especially as we get a little bit deeper into the fiscal year. As the statistics show, pretty consistent with what we've been seeing. We're not getting a lot of course applications that have to be denied. We've actually only denied 2 so far this fiscal year. In many cases, what we're seeing more commonly is deficient course applications that have to go through a little bit of back and forth with staff before they can be approved. So one improvement that we'd like to do on the CE side or with the staff side is start issuing out quarterly email newsletters to providers where we're highlighting some of the most common issues that we're seeing that's kind of causing those delays and being able to approve the applications, and just kind of open up those channels of communication with the providers so that we can really just kind of get ahead of some of those issues and help provide some additional education to the providers on the process. Also going to highlight the proposed regulations that we have that are affecting the continuing education program. There's really 4 packages that are in the works that relate to our continuing education program. The largest of which is the effort that this committee went through last year to put together our updated annual continuing education requirements with the 5 new competency areas and revamping the approval process. That package remains under development with staff. We're still targeting our January 1st, 2025 implementation date. And we're really at a phase where staff is finalizing that regulatory package so we can obtain the DCA and agency approval. And our plan is to get it out for notice and public comment in the first quarter of 2024. We're also looking forward to being able to fill our vacancy for a policy analyst position so that once we get that package out to public comment in 2024, we can hand this work off to the policy analyst for them to take it through the rest of the way of the regulatory process, which following public comment is then going to require the board responding to those public comments and adopting final text before we can implement that those new changes. We also have 2 proposals that are on today's agenda that we'll be discussing around potentially mandating basic life support certification as a condition of licensure and active status, and potentially creating the ability to grant extensions for continuing education, the annual continuing education requirements under certain circumstances. The 4th proposal that remains outstanding for the committee and will be discussed in 2024 has to do with creating an appeal process for the denied continuing education provider and course applications. As the committee may recall, this doesn't come up very often, but when we do deny either a providership or a course, CE course, the provider can appeal that to an informal conference with the executive officer. If they're not satisfied with the decision at the informal conference level, they can appeal it to a hearing before the full board. Due to the lack of any specificity in our current regulations, what that ended up requiring was that we had to pay to have an administrative law judge preside over the matter, which is very costly. So we're looking at the proposal of being able to establish that appeal process, whether it's before the Continuing Education Committee or the board, without the involvement of the Office of Administrative Hearings. So we're doing a little bit more legwork on the staff side so that we can put that proposal together for future discussion by the committee next year. The other major item, and probably the most exciting that we have around continuing education, has to do with the development of our Connect project. As the board may recall, in October, we had the prior project manager had left DCA. We've got a new team on board that we've been working with, very excited. They're very engaged and they understand a lot of our business needs. So we're working very closely with them to wrap up our business requirements for our continuing education module so that the vendor can begin building it. A few notable changes or shifts that we've made since the initial plan is that we're reducing a lot of the work in the space of applying to be a provider and that approval process so that we can allocate those hours to other improvements in the system that would be more effective. We have a relatively low number of providers themselves. So we're envisioning a system to where staff manually grants them access after they've been approved by the board, and then it unlocks the potential for them to apply for course or new courses online, add and remove course dates, upload upload their certificates and perform all the other functions associated with the providership without, creating an electronic process to apply to be a provider. It's a relatively simple process that we are planning to keep offline. We're also looking at building out then the interactive course search function that's sorely missing from our website right now. We want to replace that antiquated PDF document that's there with a real-time search tool so that providers, can display their courses, and licensees can actually go on the board's website and search for certain courses in a specific location, in a specific subject area, and actually get real-time results rather than having to scroll through that list. So a lot of exciting things on the continuing education side coming in 2024, particularly around that Connect project. And beyond that, that kind of concludes just what I wanted to highlight as far as the CE program. Happy to answer any questions from the committee.
I have a question, Kristen. The 2 courses that were denied, was there a board member involved in the process?
They didn't appeal the denial, so I actually have to defer that question off to Dixie Van Allen to answer.
I would actually have to research which 2 were denied to look back. Off the top of my head, I don't recall, but I can get back to you on that. Most often, if we are going to deny, we do loop in a board member and or the executive officer.
Okay, thank you. Yeah, if you could let me know if a board member was involved in the denial or in the process of assisting, in clarifying anything, I'd be curious. Thank you.
You're welcome.
Dr. Daniels, any questions?
No questions.
I just have 2, not really questions, just kind of interesting. It looks like in August of 2023, there was 798 hours approved, and that looks like it's more than half. Was that just an anomaly, or is there something interesting going on there?
Again, going to defer that question off to Ms. Van Allen as well.
There are, I'm sorry, which month did you say it was?
I'm looking. Well, I was just
August.
looking at the stats from the fiscal year, and when you look between July and October, and you look at August, there's 798.75 hours that were approved, and that's more than double, triple some of the other months, and it's more than half the total. So I didn't know if that was a trend or if there's something interesting that goes on in the profession during that month, or if there's any consistency to that.
It could be a number of factors. Some of the courses that we were viewing at that time may have consisted of more hours, or we may have approved, more applications. I mean, we have applications that vary from 1 hour to, 100 plus hours. So I would have to actually sample that time frame and to give you a clearer answer on that.
Yeah, no, I'm not asking for that. Thank you. I was just wondering if that was a consistent kind of anomaly, and maybe the profession really gears up for the fall. Lots of conferences in the fall. It's very busy in the profession.
Right.
It's CE in the fall. Yeah.
That's likely what it was.
And then I was wondering if there's a consistent, a consistent kind of deficiency or something that needs to be corrected, or with the applications. Like when we were talking about the newsletter, like what's the first newsletter going to be about? Like what's the main issue there?
Saida and I are actually putting our heads together and looking at the applications to come up with 5 of the most common issues that we're having with the applications. One of them that has been a long-standing issue is that the subject area that is listed on the application, either it's missing, number one, or it doesn't fit the information provided in the outline. So that is problematic for us. That's probably the top issue. The other one could be that the fees are not counted correctly, the hours aren't counted correctly. But Saida and I are compiling a list right now of at least the top 5 issues that we're seeing.
Yeah, that's great. Thank you.
Mhm.
Yeah, I think that'll be very helpful. I know I've seen our top 10 from enforcement gets a lot of traction actually out there, even beyond board presentations. We have other groups teaching ethics, and lots of them are focused on the top 10. So yeah. Okay, that's all I have. Thank you very much. Okay, let's go to agenda item number 4.
I think we have to do public comment.
Oh, sorry. Yes, thank you. Moderator, can we please open this for public comment? Agenda item number 3.
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. It looks like we do have one request for comment, Marcus Strutz. And Marcus, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
You guys hear me?
Yes, we can hear you.
Okay, perfect. Thank you. Yeah, so I heard everything everyone's saying. I think it's really important to communicate with the CE providers about what's happening with the regs that are coming up. And I know Kristen mentioned that. I know for sure many providers think Zoom's coming back January 1st of this year. So you're going to have a lot of people giving a lot of seminars via Zoom, qualifying for live. And at this point, they don't qualify for live. And I see there's and other people listening, so maybe some of them are providers, but that really is going to be a problem, because you're going to have a bunch of people providing live seminars via Zoom, because that was a date that we were given a while back, and now obviously it's been pushed back. So I think that's super important to pay attention to, obviously. And then that's it. All right, thank you.
Yeah, thank you for your comments, Dr. Strutz. Appreciate those.
All right, this is the moderator. Appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please. Thank you. Okay. Okay, so now we can move to agenda item number 4. And we are going to have a review discussion and possible recommendation regarding the proposal to mandate basic life support or CPR certification as a condition for licensure and active status. And I believe Ms. Pitto is from staff is going to give us the staff report on this.
Yes, thank you. So good afternoon, committee members. The purpose of this item is for the committee to review and discuss the pending regulatory proposal to mandate a basic life support certification as a condition of licensure and active status. Some background is that effective November 21st, 2003, the board added California Code of Regulation Title 16, Section 356.1, which required all licensees to maintain current certification in CPR or BLS from the American Red Cross, American Heart Association, or other associations approved by the board as a condition of licensure and also for license renewal. The board subsequently repealed this regulation effective May 9th, 2007, based on the following reasons. 1, the regulatory intervention had not been shown to have a positive impact on the level of care provided by chiropractors since it took effect in November of 2003. 2, the medical board, Board of Podiatric Medicine, and the Board of Optometry had repealed their CPR requirements. And 3, the board is not authorized to and lacks the expertise in approving associations to provide CPR or BLS training. Then in March 2015, the board's Licensing, Continuing Education, and Public Relations Committee began discussing the possibility of requiring licensees to complete a mandatory CPR course as part of their license renewal requirements. The committee noted that while most healing arts boards do not require licensees to be CPR certified because it's already a requirement mandated by their employer, the majority of chiropractors work as sole proprietors and should be trained on the proper procedures for handling an emergency situation that may arise in their practices. The committee agreed that the CPR requirement should be reinstated for public safety and patient protection. The committee worked with staff to develop proposed language to mandate CPR or BLS certification by all licensees as a condition of licensure and license renewal. The committee's recommendation to re-implement the CPR or BLS certification requirement was approved by the board during the July 30th, 2015 board meeting, but it was placed on hold pending the completion of a comprehensive update to the board's continuing education regulations. Then, according to the board's occupational analysis of the chiropractic profession, March 2017, page 10, 59.9% of respondents within the representative sample of California licensees reported working as a sole practitioner in their primary practice setting. In addition, 13.2% of respondents reported working as an independent contractor or associate. 11.2% reported working as part of a multidisciplinary group. 9.5% reported working within a chiropractic group. 2.3% primarily performed house calls or home visits, and 0.7% reported working in a hospital setting. Similarly, according to the National Board of Chiropractic Examiners Practice Analysis of Chiropractic in 2020, page 4 through 5, a typical chiropractor works at least 30 hours per week at a chiropractic office, which is often located in a city or a suburb. Some chiropractors were employed by a multidisciplinary health facility, and the majority of chiropractors in the United States were sole proprietors. So 13% worked in partnerships and about 17% were employed by other healthcare professionals or organizations. So since the majority of licensees practice as sole practitioners or in a chiropractic office, they are not subject to the same employer-mandated CPR or BLS certification requirements as many health professionals who work in other healthcare settings. Additionally, according to the American Heart Association, more than 350,000 cardiac arrests occur outside of a hospital each year, and CPR, if administered immediately after cardiac arrest, can double or triple a person's chance of survival. So by requiring licensees to maintain certification in CPR or BLS, the board can ensure licensees are trained to respond appropriately if a life-threatening emergency occurs at their practice. Then during the January 4th, 2003 Continuing Education Committee meeting, the committee reviewed and discussed the following recommended changes to the 2005 proposal. 1, mandate BLS level training and certification for active licensees, as BLS courses are designed for healthcare providers and public safety professionals, whereas general CPR courses are intended for those without formal medical training. 2, replace other associations approved by the board with providers approved by the American Safety and Health Institute, as those programs are comparable to those offered by the American Heart Association and American Red Cross, and also require licensees to retain records of their BLS certification for 4 years from the date of completion and provide those records to the board for auditing upon request. The committee also discussed the need to develop language for active licensees with temporary or permanent disabilities or medical conditions that may prevent them from being able to physically perform CPR and obtain the full BLS certification. Staff researched available options and found that the American Heart Association offers an advisor BLS course that is intended for individuals with disabilities who have passed their online course and have knowledge of the BLS skills, but due to a disability cannot complete the psychomotor skills testing portion of the BLS that is required for the BLS completion card. By successfully communicating to someone else how to perform CPR, these individuals with disabilities can receive an advisor BLS card instead of the BLS provider card. Additionally, staff contacted the Dental Board of California to inquire if they offer any exemptions to their BLS requirements to their licensees with disabilities. The Dental Board confirmed they do not have any exemptions to their BLS requirement. However, they do offer an inactive status, which does not allow the licensee to engage in the practice of dentistry. Staff recommends that the board handle requests for exemptions or extensions to the BLS certification requirement due to temporary or permanent disabilities or medical conditions under the same process being developed for the annual continuing education requirement under agenda item number 5. In your attachments, you have the proposed language to amend CCR Title 16, Section 371, and add CCR Title 16, Section 371.1 as approved by the board on July 30th, 2015. And you also have the draft proposed language to add CCR Title 16, Section 371.1 for basic life support certification requirement. So the committee is being asked to continue the policy discussion regarding the implementation of a BLS certification requirement for all active licensees and provide policy direction to staff. So with that, I will turn it back over to the committee.
Okay, thank you. And thank you, Ms. Pitto and staff. That was very thorough, very helpful background information for this discussion. So really appreciate all of that. I think the first thing I would do is just open it up to the board members for any further discussion.
I'm all good with the proposed language. I did have one question, and that is that because in there we talked a lot. There was a lot of discussion about license and for inactive license and those types of things as it relates to this, but also that when we're making provisions for other people in some of these aspects, that what about addressing the doctors that are not actively practicing but keep their license active and are teaching seminars or teaching in the university setting, chiropractic college setting, and them being exempt from doing the CPR aspect since they're not in day-to-day active treatment with patients. Are we going to require them in that setting to do BLS?
My recollection was that some of the conversation around that question was that once we give them an active unrestricted license, we have no way of controlling what they might do with that. And so that would open the opportunity for them, even though at the moment, maybe at the time or at the time of their renewal, they were engaged in only academic, or maybe they're only maybe they're not seeing patients at all in some, but doing CE, et cetera. I guess I would have some questions as to, why they would need an active license, but that being beyond that, I would think that my thought initially would be that we would require them to comply with all the requirements of having an active unrestricted license.
This is Sabina. Good afternoon.
Hi.
Hi, everyone. Yeah, I just wanted to chime in. You're absolutely right. If this is going to be a requirement for an active license status, then we can't keep track of what people do with their license, right? We don't have any way to track how they're using their license necessarily. So if the board ends up going that direction of this is a requirement for active license renewal, then it's going to be for everybody who has that status. Depending if you have an inactive or a retired status, that's something completely different. And I know your regulations council is on here as well, but I just wanted to chime in.
And Sabina, can you just identify who you are just for the callers? We have 9 to 10.
I'm so sorry. This is Sabina, legal counsel for the board, general legal counsel for the board. Your regulations counsel, Mr. Vong, is on as well.
Thank you.
So my question was more about the exemption, since we have discussion there about exemptions. for temporary or permanent disability, which might exclude them from that there might be a provision as an exemption for people that are not actively practicing, but maybe teaching in the college setting or teaching in a
Right.
that's what I was referring to is when we were talking about exemptions, because we are referring to that some people will be exempt from having to do this because perhaps they have a disability that would not enable them to actually activate the BLS system in the same way that some are. That's all I was referring to, is that we have a provision
Right.
for people in that regard.
Correct. However, I don't know if the board staff and the board wants to get into the business of keeping track how a person works. It might be a big chunk to bite off because, then would the active licensee be required to keep, the board up to date on every change of employer? I'm not sure how the staff might keep track of that. Could they potentially lie? And I mean, this is a weird thing to lie about, but how do you make sure, and I don't know, it's a lot, it would be a lot of staff work. I'm not sure how they would track that, how they would keep track of employment and verify that, because there will be a process to go through if someone does request an exemption, right? And they would have to verify through doctor's notes or whatever the process might be. So there will be added staff work anyway on that end, if it's a disability or medical reasons. I'm not sure how the staff wants to potentially tackle, and then where do you draw the line? What kind of work environment do you draw the line in?
Yeah, I would say though too that the work environment is not the pertinent issue here. That's not the rationale for applying for an exemption. They may be teaching because they are disabled, and that's how they choose to get their income, but it's really the disability that if they have the disability and then they want to have an active unrestricted license. I don't think for our purposes we would differentiate what they then do to earn income in the profession. It's really just a matter of, do they qualify, and then they can go endeavor to work however or wherever they'd like to. So I don't know that. I think that's maybe a little bit of kind of secondary, or I don't think that's the core issue. I think the core issue is do they qualify for the exemption because of the disability. And then if they choose to practice, great. If they choose to teach, great. If they choose to do CE, great. I'm sure there's other jobs where you might want to have an active license and not necessarily see patients. So I don't know, does that sound correct?
Are you talking to me, Dr.
Yeah, I'm just asking legal.
Yeah.
I'm asking you, Ms. Knight. Like, I mean, it seems like that isn't really the issue we necessarily would be focusing on. We would be focusing on, do they qualify for an exemption first and foremost, not necessarily instances where they, if they want an active unrestricted license, and they have a disability, then to the CPR requirement, then from there it doesn't really, I don't know that it matters if they were, work in an education, or they either qualify or they don't.
Right. Absolutely. Absolutely. Like I said, we can't really keep track of where everybody works and whether or not they're seeing patients or not. If they complete the exemption process to the board staff approval, then obviously they get an exemption, right? No matter how they use their license. So obviously, if we have an exemption process and whatever that process might look like in that procedure, and they go through it, then great. And I was just commenting on, we can't possibly keep track of where everybody works and issue exemptions based on that.
Yeah. Okay. Dr. Adams, is that discussion helpful, or is there any more to discuss there?
I hear both sides of it. I'm just thinking in terms of, my father wants to keep his license active, but he's 87 years old, 88 years old. He's not actively practicing. and he, he doesn't have, quote, a disability where he can't, physically get down on the floor and resuscitate a dummy in, BLS or that type of thing. But this probably would be a reason why he would not keep his license active and let it go, because it's, he's going to have to do some of those things and probably too proud to ask for an exemption. But I was thinking more along the lines of the fact that, if somebody applies, I mean, I guess I didn't think about the fact that I never thought of the board having to keep track of where people are working and what they do. But we're using the rationale that 80% of chiropractors are sole practitioners, so they should be able to be trained in BLS in the event that emergency happens in their office. But if they're not actively practicing, they're kind of out of that particular realm of practice. And that was kind of the primary rationale behind the implementation of this. And it's just a good idea. But I'm thinking I was thinking along the lines of that, 12,000 plus chiropractors in California. There's probably not going to be a lot of people that would be sending in a form that would say, hey, I am not actively seeing patients. I am not in a practice. But I teach continuing education, or I teach at a university, and am I required to? So that's all I was bringing it up for. And you've said that that's going to be too much of a hardship on the board, so I accept that.
Thank you. Is there any other discussion on that issue? No? Hearing none. I have one question
I had a
on the,
question.
I'm sorry, go ahead.
Ms. Pitto, you had mentioned in your review that the previous board said that there had not been shown to be a positive impact on the level of care by the licensed doctors of chiropractic. What was their measurement? What was their rubric to determine that there was no positive impact?
I'll have to defer that question to Kristen.
Sure. Yeah, I can answer that question. So the short answer of that is that there was no rationale behind that statement. At the time that this regulation package was repealed in 2007, the requirements for doing so were nowhere near as stringent as they are today. So when we reviewed that package, the underlying package to repeal that regulation, it just simply stated those three facts without actual data behind it. If I was to look at the data today, I mean, you're talking about a 4-year period. So in my opinion, it wasn't really given sufficient time to measure, but there was no underlying data behind that rationale for those 3 points of why they repealed it.
Okay. So there was just statements that people said.
Correct.
Okay. I also had a question on page 2 of 3 of attachment 1. Actually, hold on. Oh, sorry. It's page 2 of attachment 2. So it says that, or the proposed language under F number 2, it says ensure that another licensed doctor of chiropractic or support staff with a current certification in BLS is on the premises. That doesn't seem to be, that seems to be a little bit incongruent with somebody who has an advisory card. What proof are we, the board has a responsibility to understand, like, if someone says, oh, they have an advisory card, that means the board needs to make sure that somebody is in that person's office that can perform CPR. And so if they're designating a staff person, like if you have an advisory card, supposedly you can instruct someone to give CPR who is not certified. So that language for me is not complete or is very confusing, and it doesn't incorporate all the particulars. So if I have a disability and I get an advisory card, what proof do they show the board that they have a staff member? Are we going to require, an employment application? Are we going to require the staff's driver's license? Like if we're going down that road, what, then the staff quits. And then what amount of time is that licensee going to be required to say, okay, there's somebody else here that can perform it? So, I mean, for me, there's questions around that and there's issues. The other is, I called American Red Cross and talked to them extensively about what the advisory card was and how they handle disabilities, because there's a statement in the proposed regulation as far as it won't violate the American Disabilities Act, but to me that's very vague. And so there's the advisory card, they're not saying that that person can verbally teach somebody CPR in an emergency situation. So an advisory card, like for you, Dr. Adams, would be your dad. He doesn't want to get on the floor. He's not practicing anymore. He can just do the online class. It's very easy. He can do the online class. He could get the advisory card and, not perform the skills. Or somebody else could go to the class and do the advisory card, and they're a doctor in a practicing, in an office. They don't have a staff that can perform it, but they've never been tested on their communication skills to be able to communicate how do you give CPR to somebody. I mean, that's a teaching skill. And just so you know, like they're not testing the individual on that. So I just think we need to be aware of what an advice, it sounds nice, but like what that is and what the purpose is. The other is, and again, to Dr. Adams' point with the advisory card, I mean, there's like one study done on lower weight individuals have a difficult time performing the skills. And I see it every time I go, more often than not women, but there's men as well. And there was a study published that if you were of a certain weight, you actually have a physical difficulty in performing the skill set. And, when I talk to them, and I've seen it in the class, they do everything they can to help you pass the test. By no means does that mean that that person is comfortable, competent, and in that case, to me, them getting an advisory card with a sign posted on their door saying we do not perform CPR here, but they could have an advisory card that keeps them appropriate with their license, compliant with their license. But we have to be reasonable. I think we want CPR not to be punitive to our licensees, but to be better practitioners and to be safe. And as Ms. Pitto said, 80% are sole practitioners. But to Dr. Adams' point, a lot of people are teaching, but to me, if you're a licensed individual, you're held at a slightly higher standard. And I think that you need to, especially if you're teaching students, you should know CPR. And if you can't perform it, that's absolutely fine. You get an advisory card and you just, make a statement, especially if you're in a classroom setting or something anyway, so I just have a lot of sort of questions, and I'm not really sure I'm understanding sort of the language around that. The other with the disabilities, I asked them because there was a paper done on if you could do it one-handed and you could get the depth, can you get your card? And they said, absolutely, yeah. So if you have a shoulder injury, but you can actually demonstrate that you can do it with one arm, then you can actually pass the skills test. So when we're talking disabilities, there's different types of disabilities. There's, maybe not a disability, but a concern if you have a smaller woman and yeah, she passed the test, but she's not really comfortable. If she's I don't feel comfortable doing this, I want to let the stakeholders know that I'm certified and I know it, but I don't perform the skills. So those are some things that are my concerns.
Great points.
Yeah, I think I had some notes too along those same lines. So I'd just say that I share a lot of those. I kind of felt like the under F2 in the proposed agenda item number 4, attachment 2, the proposed language under F2, that the requirement to have somebody else on the premises, I felt like that might represent kind of sort of an undue burden. And but that was, I, and so I know Dr. Adams had mentioned at a previous meeting other mechanisms like advising the patients as part of, as part of the um, something that's publicly available in the office, that they inform anybody that they might do an eval on or treat, that office, whatever level they're at, whether it's an advisory card or they haven't, that they will not perform, but that I think you had said, Dr. Adams, at a previous meeting, that inform them that they will activate the EMS system. And
Yes, I mean, there's people out there that are, practicing sole practitioners that are seeing, just a handful of people a week, and they're still going, but they're not physically capable of doing this.
So
Well,
I think
that's where I think that we have that notification, and it's very easy, like, when I get the fire inspector that came by, there was things I had to change, and all they required was once I changed them, I take a photo and I upload it. So, my thought is, like, the person can take a photo of a sign that's posted on the outside of the door. Sure, they can always take it down, but whatever, that showing that they're notifying the people walking into the building that they do not perform it, but they will activate the EMS system. And then they can also just have something on the informed consent that's very, a one statement that's very easy to add. Those are some ideas.
Yeah, I think a good a good place to be might be that everybody, the minimum is that if you have if you apply for an exemption to have an advisement card, am I saying that correct? Advisement status or
Advisory.
advisory card, that then we just have the appropriate public notification, and with also the acknowledgement that they would immediately activate EMS. And if there is, I think we could develop the language maybe if we need to, but that also notifies them that if somebody's what the advisory means, that means that they don't physically perform it, but they know it. They understand CPR, and that they could potentially, if anyone is present, not only activate EMS, but also instruct somebody on how to perform it, somebody that is physically able. I think it would have to be the kind of if present, to help satisfy my kind of thoughts on the undue burden that I had mentioned in F2.
Well, you can see very quickly that the exemption hole just opened up.
Well, and I guess for me, I wouldn't call it an exemption. I would just say it's a clarification. Like, I feel like everybody can do an online class or go and sit in a class and do it. But an actual exemption to me might be something, I don't know, I think that we need to discuss what we mean by exemption. Is that somebody who is blind, who is hearing impaired, who is in a wheelchair? What does that mean and what does that look like? Just to put it in one broad thing doesn't violate the Disabilities Act, especially in litigious California. I don't know, for me it's vague, and I would like more clarification around it.
Well, I agree, and I think the term qualified disability is what you're looking for. I mean, it has to be a qualified disability that's documented. But you brought up a great point, and that is that, well, what if somebody's small, and they can't, they don't feel comfortable. They've done the physical skills, they've taken the course, but they're like, I just don't think I can physically do this. That's not a qualified disability. That's a comfort level.
Well, and it's a practical level. I mean, I'm old school. I go and I do the skills thing. I have my thing next Friday, and most of them are nurses in there. That's just the demographic, and a lot of them are tiny women, and they are struggle to get the depth on the mannequin. And the teachers are great. They do everything they can to accommodate them, but I don't see them as being comfortable in an emergency situation that they could actually do it. So I feel like we have to have a bucket for them, with,
Right.
yeah.
That's what I'm saying. The bucket is gotten a lot bigger just with your comments. So that's all I'm saying, is that I think we, you hate to keep kicking this can down the road, because I think it's a good thing. But I think it, from a regulatory language standpoint, we have to be very clear, because if somebody just says, I'm not comfortable, so I'm gonna get an advisory card, and then I'm gonna put a notice on my office that says, I know these skills, but I'm not really comfortable doing them, and that satisfies the requirement, then if that's what's required, and that's gonna satisfy, cross the T's and dot the I's, then I think that sounds great.
I mean, I think that's fair. I like that suggestion, because, the fact of the matter is that ultimately you are never under a requirement to perform CPR, even if you are trained, even if you carry an active card. There's scenarios and situations where you may decide that you do not want to perform it at that moment, or perform only portions of it, where maybe you're only willing to do compressions, you're not willing to do mouth to mouth. So I think having, us kind of acknowledging that, and having the ability for providers to have the option to do an advisory card, and then also just the acknowledgement to patients that, that's the option they chose, and what that means to them. I think that's, I don't know, I'd be happy with that.
Yeah, I'd love for our counsel Sabina to weigh in on that. If that protects us as a board, though, that we, that nothing can fall back to us, because if somebody says, well, you have the skills, you didn't act. You're right. Nobody's forced to, but you can imagine that might be a potential sticking point if you could have done something and you didn't, other than activate the EMS system by making the call to 911 and activating the system, which you should do anyway. That's one of the first things they tell you to do, is tell somebody to activate the EMS system, and then you go forward and proceed if you're doing so.
Right.
And I think the Good Samaritan laws clarify a lot of,
yes,
yeah.
Right. This is Sabina, exactly. And, we have those, of course, Good Samaritan laws that cover for a lot of everybody who tries to help, or, does what they can to help. But, we need to, that can be looked at later, and maybe how other boards may have even tackled it or not tackled it. However, I think we need to, make sure we continue our focus on what's in front of us today, and what you want staff to either do more research on, or samples of, or if you're ready to bring it to the full board, or if you have, if there's specific regulation or language questions, you have your regulations council here as well. If you have any other, questions about how other boards are handling this, I know you've talked about a couple others, but I don't think the duty aspect is necessarily something that's going to come back and bite you, given Good Samaritan laws. However, we always like to look to see how other entities also cover this, because, like you said, employers require it as well. I mean, I'm a coach for USA Gymnastics, and it's required in my workplace as well. And, we go through it every year. I wouldn't be comfortable doing it. I would be frightened because I've never done it, but I would definitely be activating the EMS and doing what I can and what I remember. I just would be so scared I'd be messing it up or hurting somebody more. But I'd let Mr. Vong also chime in here.
Yeah, so I wasn't at the last discussions, but happy to help research if the board has any additional questions. And I'll also defer to Ms. Walker too, who has done most of the staff side research on this.
Sure, thank you. And if I could just add, thank you for the discussion today from the committee. What staff is really looking for is just the framework of what we're going to end up developing. So I wouldn't put as much of the focus on the text itself, just more around the concepts. And really, from what I'm hearing from the discussion, my recommendation is really to focus on the educational component. We've identified a need that licensees need to know this information and stay up to date with it. We kind of end up, unraveling down the rabbit hole of the advisor card and under what circumstances somebody may get that one. But if it's, if it sufficiently meets the need of protecting the public, that licensees to have an active license, either, possess the full BLS or an advisor, if it's appropriate to their scenario, without even the board being involved, it's just they either have, the BLS or the advisor card, and they can provide proof of that. If that's sufficient for public protection, we can draft language around that. If we feel that we need to have more on top of that, whether it's, something along the lines of a, patient notification that, I possess a full BLS card, but I won't act if, if something happens, I'm not comfortable, we might be getting a little bit too far down there. Because what we're seeing with the other boards is they have requirements that if you want an active license, you have to have a BLS certification. Otherwise, you can't have an active license. We've gone a little bit further in digging into the different scenarios that can be involved with that. But if really to meet the public protection need is the educational component, my recommendation is potentially that we draft language around requiring that they either have the full BLS certification or the advisor, and maybe that works. So I just kind of wanted to figure that out. Is like, do we need to go to the point of public notifications, or do we want to focus on just the educational component? And like I said, once we kind of figure out that framework and what the committee would like to see implemented, that's when we take it back, and Mr. Vong really assists us quite a bit in getting language that reflects that policy direction that the committee would like to see.
Well, I mean, I think that's partly why we're having the conversation, is to figure out what does equate for public protection, not really going down the rabbit hole, but we need to have the conversation of what is an advisory? What does that mean? What does that look like? Is that enough? So I think that's why we're having this conversation about that. And then, obviously the language needs to be clear with that. I mean, my viewpoint is that the public needs, if you only have an advisory card, the public needs to be notified. Whether it's, and I think it should be on the place of entry and or an exemption, both are fine, but I think the public needs to be notified that what they're walking into. Because I think people subconsciously relate health facility or a doctor's office with a place that they're taken care of or safe. And so there's an implied, perception of that maybe this doctor knows it. So I think my personal opinion is that the public needs to be notified if that is not happening, so that they are very aware. Say you have a geriatric person coming in and they see the sign and, it alerts the partner or whatever to be like, oh, okay, they don't do this. I need to be, more aware or whatever it is. So in my opinion, I think the public needs to be notified. And to me, it doesn't matter in the sense, like it was made a comment like pediatric board doesn't require it. I don't care in that sense what other boards are doing. I feel like we need to hold our licensees to whatever standard that we want. And I think the information is there that we need to know. And one of the reasons this came up was because of an enforcement issue of someone not calling EMS when they should have. So I think that that's why so I guess the question to Dr. Adams, Dr. Paris, is having an advisory card and or BLS and notify, like what is enough to ensure public protection?
Well, if I could, just for expeditious reasons. I think I feel like I've had a good discussion here. I would like to make a motion that we refer this back to staff with the suggestions and discussion that's been had with respect to attachment 2 F item 2, which I think is kind of part of the issue here, that if a person doesn't feel like they can do it, or has a temporary or permanent disability that would preclude them from doing that they can still meet that requirement by having an advisory. So I think I would motion that we refer it back to staff to do a little bit deeper dig on some of those aspects, and then come back with the language that might satisfy that that concern that we have.
So would that be F2? F2 language would essentially change. I mean, assuming we keep F2, I mean, I could go anywhere, I guess, but seems appropriate there that instead of stating that what it currently states, that ensure that another licensed doctor chiropractic or support staff with a current certification in BLS is on the premises at all times, that would shift to change what Dr. Daniel said, which I will say I was in agreement with, that the language would note that if they have because it's under F, which is that, I guess that would say if they had the advisory card, that they would be notified. So F2 would change to the notification language. Would that satisfy it? I mean, if we add in the BLS
I just
or
think
advisory, if licensee has an advisory card, thou shalt notify the public via this type of language.
Yeah, but I mean, think about the person that's the solo practitioner that answers their own phone and doesn't have another person. So that person then can have an advisory card and then lets patients know, I have an advisory, status with this. I won't be performing this, but I know how to activate the system and I will do what I can. But, whether we say it's on the door or whether it's in their intake forms, the patient needs to be informed.
Yeah, that's what I'm saying. Yeah.
I agree.
Yeah, so the F2 language would go away. That was my concern. That seemed like an undue burden to hire another staff
Well,
person.
I think that's really the only thing here, because this is related to people with F2 is people that have a temporary or permanent disability. So the person that can activate the system and feels comfortable doing it, none of this applies. They'll have their certification. This is really for the people that, as Dr. Daniels has pointed out, that either they're small framed or whatever the case might be, and they choose to have advisory. They need to inform their patients of that. And they don't necessarily fall under F2 because they're not temporary or totally disabled. They're just a person that doesn't feel comfortable. So I think what Dr. Daniels is saying, and I agree, is that there are some people that may not be able to physically do it or feel comfortable, but they're skilled, they have the knowledge, and they'll certainly activate the EMS system and they'll do what they can. But I mean, it comes back to, you're just kind of covering, what you need to cover to let patient. And I think it comes back to protection of the public, is that, a patient, anybody that comes in your office needs to know what they're coming into. And if someone's not feeling comfortable, they should know that so that they can have the option to maybe go somewhere else if that's a deal breaker for them.
Yeah, no, I think we're all in agreement. I didn't mean to kind of confuse the issue I just, to me, F2, I would suggest that we eliminate that language, but I guess putting it back to staff, they could decide whether it requires G and, separate language under another, another letter, just to identify all the issues we just discussed. So, yes. Ms. Walker?
How does that sound? Is that motion okay?
2 points. Dr. Adams, we don't need a motion to return to staff. You're welcome to make one, but just as a point of clarification, staff, is going to reflect the entire committee's discussion and take it under consideration and bring it back as requested. We don't need a formal motion, but the reason I actually raised my hand for it was just 2 points of clarification, just so we can make sure that what we're crafting is meeting kind of the consensus that the committee's coming to today. The first of which is, does the committee intend for the board to be the one that's keeping track of whether somebody has the full certification or the advisor card? Meaning, you know, if somebody plans to get an advisor card, is it sufficient for them to pick their own path? And if they're audited or when they're, you know, uploading it in Connect, we identify which one they have, but do they have to apply to the board to tell us why they need an advisor card, or is it sufficient for them to make their own decision? And the second point of clarification is around, there's been a lot of discussion today around people that, whether they have the full BLS card or the advisor card, don't feel comfortable acting in certain scenarios and will just activate EMS. So that advisory that we're talking about putting out to the public, is that only for people with the advisor card, or are we extending that out to anybody or any licensee that, you know, just they intend to call EMS if an emergency occurs, they don't feel comfortable performing CPR? So just those 2 points of clarification. And I think we've got some good framework here to bring back something that the committee, along with the committee discussion today.
Can I go? I'll go first, I guess. So regarding the notification, I think anything less than the full BLS certification, that to me that would arise to the level of, you know, notification. I don't know that. I think if somebody has full BLS certification, I don't know. I mean, I guess they could decide in advance they're just not going to do it anyway, but I'm not, I don't know. That just seems like a kind of an unusual place to make that decision well in advance of the specific scenario. And, you know.
Yeah, I agree. I think you can't legislate what someone's going to do with it. If we're requiring them to have it, what they choose to do with it is up to them. I think where we come in from protection of the public is if someone's basically saying from the get-go, from an, that I want an advisory card because I'm not going to be physically doing it. I think that person does need to notify the board of the course that they're taking, and they need to either post in their office or in written form in their office, informing patients that they are not going to be performing emergency or BLS services other than activating the EMS system in the event of that situation, of an emergency situation arising. I think that's appropriate for protection of the public, that a patient should be informed if they're going to an office where somebody is openly not going to do it.
Yeah, I agree. I mean, I think just notifying the board, I mean, hopefully it's not many people, but we want to allow people who are only doing nutrition, you know, whatever, those other people, notifying the board, and then they need to let the public know. And then, you know, maybe it's just a quick form, you know, in the Connect system that states, you know, the reason why, just something very simple. I don't see that as very time consuming. But those would be kind of my 3, you know, suggested requirements.
And I apologize for getting so far in the weeds, but I just want to make sure we can get that language right. Acknowledging that they're going to notify the board, is that an advance notification and they have to get approval from the board to get the advisor card, or is it just a tracking method so we know, you know, potentially when we're doing inspections, we know which requirements they're subject to? Because it could go either way. We could go through
Tracking.
Yeah, is it
Tracking.
Okay, gotcha.
Okay.
Can you clarify what you meant with that comment, that the board will track it, or that they need to advise the board? Is that, I did, maybe you cut out for a second there.
Sure. So, so what it sounds like the consensus is what this will end up entailing is, you know, when we get in the renewal process for the license, it's a condition of active licensure that you possess either the full BLS card or the advisor card. So we would be inserting a question on the renewal application where, you know, providers, just like you certify your CE, you'd be certifying, you know, that you possess, and you would check a box. You would possess either the full BLS card or the advisor card. You select advisor card, we could build in, you know, where you put some substantiating information, as Dr. Daniels talked about, for that.
Right.
That would be if we're tracking and, you know, collecting the
Right.
data, but not adding another layer of complexity with an additional process for them to formally apply to the board to get a modification for the advisor card. So it sounds like we're just going to collect that information and then we would have it on file, which sounds reasonable for us. And
that if they do choose the advisory course, they need to inform either in writing in their office or in documentation that they are not going to be performing it and that they will activate the EMS system.
correct. Yeah. Well, we
Okay.
can include even to the level of detail on a renewal form, an acknowledgement that they, you know, annually they acknowledge they understand that requirement if they
Yep.
Yeah.
Yeah, I support that. That's great. So if we don't need to make a motion, then great. I think we're on the same page.
Is there any other discussion? Okay. I just have one more quick thing. So 364H is exemptions and reductions of requirement. H particularly applies to board members. And so I would just add point to, and I'm not sure if there's an issue there or not, but to clarify that the CPR BLS requirement would still apply even to board members. I don't even know that we need to do that, but it just was running through my head that there's an exemption to CE, but that would not apply to this regulation. Is that correct?
That's our understanding. The intent was that it's separate from CE, but we will make sure when we're checking that language that there's no inadvertent exemption for board members.
Yeah. Thank you. Okay. Is there any more discussion? No motion here. So can we please open agenda item number 4? Moderator, can you please open for public comment?
This is the moderator, and at the direction of the committee, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. And it looks like we do have a request from H.A. Bud Walker. And Bud, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
I have been a sports certified doc for almost 40 years, and I know that we are held to a higher standard. Under that statement, I need to find out, is there a statement in your certification requirement that also requires DCs to have an AED on site? If you're going to require BLS, are you also going to require AEDs? Second question I have, if a DC decides in advance to not do the procedures involved with BLS and post it, etc., and then a circumstance arises where they do perform BLS, are they going to be in any kind of legal issues, etc., because they decided not to and then they decided to? Those are my 2 questions.
Well, thank you for your questions. Both important issues. I think to the second question, not that we can discuss those here today, but I think the Good Samaritan laws cover a lot of whether individuals and including licensees decide to perform or not perform there. And thank you. I think the maybe for a future call or while we're developing language, we can. The AED that was not discussed as being required though, as part of this, even from our last call.
Understood. I just didn't see any documentation in front of me that I could refer to that I could answer that question myself. So I thought I'd bring it up in public discussion. So I do understand. I have done CPR outside of my office for a gentleman that we saved his life and he got another 16 years out of it. I will tell Dr. Daniels that under circumstance, I could see a 6-year-old child doing that because the adrenaline that races through your body gives you superhuman strength. So yes, it is an issue, but it's you learn it, you remember it, you do it. I will guarantee that happening. So thank you for your time.
Thank you for coming on the call today. Appreciate your comments.
All right. So some moderator appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please. Thank you. Okay. Moving to agenda item number 5. Again, review, discussion, possible recommendations regarding proposal to create a process for granting exemptions or extensions to the annual CE requirement to licensees who have been adversely affected by natural disaster, state of emergency, medical condition, or other hardship during their license renewal period. And sorry, I'm bouncing back and forth here. And I believe Ms. Walker was going to provide the staff report for this agenda item.
Sure, yes, thank you. So just a little bit of background information of how we got to where we're going to be going for today's discussion. So really in late 2021 through early 2022, the boards at the time, the Licensing and Continuing Education Committee, really engaged in a series of discussions that were originally intended to explore whether the board had the authority to issue waivers. And it was specific to, in a lot of ways, the COVID pandemic, really looking for whether the board had the authority to issue broad waivers for licensees that were affected by a natural disaster or a state of emergency. Where those discussions ended up evolving was, as we did more research with legal counsel, we really found that, the board lacked that type of broad authority to be able to just, under certain circumstances, waive requirements for licensees, that are either subject to, specific condition, or they are, they happen to be in a specific area that was affected by a natural disaster. And what that evolved into was the drafting of language to where the board, on a case-by-case basis, could grant an exemption to CE requirements with appropriate substantiation of a hardship from the licensee. That's the language that's in the packet, and it was last considered by the board in April of 2022. It was all centered around how a licensee can provide satisfactory proof to the board that they've been adversely affected within the last year by a natural disaster or state of emergency. And then that language went into detail of how would they go about making that request to the board, having it approved, or if it's denied, how they can request a repeal or request reconsideration of that denial. What staff is really requesting from the committee here today is a very broad discussion of not only that pending regulatory proposal, but really the need for us to potentially explore broadening that to include other types of hardships that licensees often encounter during the license renewal period. We frequently, as much as it's ideal that, people do their continuing education ahead of time, but sometimes, you get down to the last 60 days prior to your license renewal and you're involved in an accident, or you have some sort of medical emergency that puts you out of commission for a set period of time. Under our current regulations, we don't have any mechanism to provide a remedy to that when it occurs for a licensee. Their options are to renew as inactive and then complete their continuing education when they're able, and then pay the fee again to reactivate their license to active status. We don't have any mechanism to where staff can grant like a temporary extension to that requirement, or if they were subject to a fire or things to that extent. So the discussion here today that staff would really like to just begin with the Continuing Education Committee has to do with how do we account for those circumstances. And what's changed since 2022 is with the development of our Connect project, we found the ability for us to be able to retroactively apply CE credits to prior renewal cycles, which has always been the challenge in past years. So when you look at the language that was considered in 2022, it's all around granting an exemption. So if something happened to you in 2023, you're off the hook for a year, and then in 2024 you resume and complete your requirements. Well, we now have the ability to be able to move and shift more towards an extension, so that you're not waived from completing the requirement. It's just we can build in a reasonable time frame for you to complete those courses, submit that information to the board. We can retroactively apply those credits to a prior renewal cycle and prevent the system from counting them towards your current renewal, so that we ensure that you completed your 48 hours within that calendar year. You've caught yourself up. So we wanted to start that discussion and really shift the focus away from the idea of an exemption to an extension, and then entertain what that could reasonably look like with timeframes. Staff had kind of proposed out there maybe up to 180 days with the circumstances. Also looking at what other factors could qualify, like a temporary or permanent medical condition or disability, maybe having to care for an immediate family member. We could come up with a list and start working on it from there. But really, that's the focus of it today. Is we have the language that's in the comprehensive CE proposal that really narrows the list of people who are truly exempt from the CE requirements. There's five groups. To be exempt from CE, you have an inactive license, you're in your first year of licensure, you're a chiropractic college instructor, board member, or a licensee who's been called to active duty military service. Now with the 364.1, that's the regulation number that we plan to assign to this idea of an extension process. And for purposes of entertaining the discussion today, it's really just developing what that framework could look like around that, identifying the types of scenarios under which we would allow for an extension. And then, like I said, we've discovered a method to where we can track it on the back end. So with that, I just turn it over to the committee to kind of just begin that discussion. If there's agreement, of course, staff's going to develop something much more concrete. But what we're really looking for is the committee's buy-in to expand this proposal beyond just the natural disaster state of emergencies and include other hardships with an extension process.
Thank you. Apologies, I dropped my computer, just dropped me right off of this. So I was off for about 15, 20 seconds. So I'll just open it up for discussion to the board members.
I'll start. I concur, Kristen, with everything and looking over the language and the suggestions. I like the suggestions. I think expanding it, to the degree that, that you feel that you're capable of as a staff. You don't want to open it so much that you're getting inundated, obviously, but which I don't think you probably will. But in the event that there are those individual situations that come up, that hardships do happen, that you should have that ability to do that. So I like what's proposed, and I like the suggestions that you have, and encourage you to do that, and then bring it back to us. Be great.
Yeah, I kind of feel the same way. I don't have much to add. I think they're all good suggestions, and I think if we develop some language around that, I think that would be very useful and probably something we'd all like to move forward.
Kristen, I just had a question on two things. The appropriate substantiation. I mean, I think it's sort of in A, B, C, and D. But then in number 2, it says the board or its designee may approve or deny. And I'm just wondering what is, and maybe will be defined in the language that you come back with. I'm just wondering, like, what's the rubric or the measurement to define, approval or denial. I just want to avoid someone's opinion approving or denying. And I feel like, having some sort of rubric to define it. So maybe that's in the works. When I read it, it just seemed a bit vague to me. And then the other is, and I don't know how the board members feel about it or how I feel about it. As I was reading it, I was just wondering, what if there was, in addition to an extension, what about allowing a one-time, which is sort of this, but a one-time postponement within a licensee's, and so they get to choose what emergency is their emergency that they need to have a postponement without, approval. It's a one-time thing. You don't get it twice, so it was just an idea. I'm not really sure if that would work or not, but say a family member dies or they have a last minute emergency and it was a suggestion.
Thank you for that. And that's a good suggestion that we can, that we'll explore further. Yeah, one of the reasons that the text itself was returned to the committee had to do around more of the approval process and wanting to really vet that a little bit further. The purposes for putting our language together, we would want it to be very clear to the licensee the circumstances under which it would be approved or denied, which is really demonstrating that the hardship, prevents them from being able to complete the continuing education requirements prior to the renewal period. I also did want to add, I forgot when I was summarizing to highlight, really the purpose here too is to make sure that that request is made in advance. So prior to the license renewal application being submitted, because really the intent is to ensure compliance, not not to provide a loophole if you get selected for an audit, you didn't do your coursework, and then you've got a note at that point. It's really to be, there's a legitimate issue. We do get them, we do get people with different circumstances. They do reach out to the board ahead of their renewal, but unfortunately we don't have a mechanism to address it yet. So yes, yeah, the language itself will be a lot more clear. Even we'll play around a little bit with the, the board or its designee. I'd say really the intent there is, for the executive officer to review it. And then if the person appeals the decision, maybe it goes to the continuing education committee. So we'll vet that a little bit further as well, but just wanted to, make sure there wasn't, there wouldn't be any issues with the committee if staff explored this beyond just going to the natural disaster state of emergency, if we could also incorporate, the other types of hardships that we often see from our licensees.
Yeah, no, I really like that you brought this to us from that perspective too, because it just feels a lot more comprehensive, and we can do this once until next time, but at least it'll be fairly comprehensive. I would say there's only one thing, and this is so minor, but when I was reading just some of the language there from the April 22, 2022 board meeting, the draft language, it doesn't note under B, it doesn't really make a statement as to, it says the licensee's address is associated with an area. And I'm wondering if maybe we should consider clarifying, if that's home address or business address, or is it both? And so but it's really minor, but anyway, it had me scratching my head a little bit when I was reading it.
Thank you. That's a good observation. And I think the intent there is actually for either scenario, because either one would likely be disruptive enough that it could postpone your continuing education. So, but we'll
maybe it might be more appropriate to have it say something like this licensee circumstance associated with their ability, instead of, their locale. I don't know if that makes a difference, but because their circumstance could be their home gets burned or their office gets burned. Or both. If they lived in Paradise, they might have lost both. 85% of that town got burned, so that would have been a significant hardship.
Yeah. Okay.
Yeah. Anyway, I like it. I recommend.
Yeah.
I would say this one thing. I'm more inclined to say, someone getting an extension, since you have the ability to give an extent. If there's a hardship that's been qualified by the board, I'd rather see an extension rather than like them getting, the ability to just waive it, for that year. I think giving them up to 180 days to retroactively do for that year is ample, unless there's if their condition is such that it requires longer than 180 days, that can certainly be something that maybe you put in there, that if it requires longer than that might be warranted.
I would agree with you. I would prefer to see just
thinking like a coma or something real significant, cancer, or something that might not be resolving in 180 days. And in that case, they might not ever come back to practice. I don't know.
Yeah, I would just in response to that point, and then we'll make sure that we have some pretty broad language there. But just to that point, there was, in the existing CE regulations, they're all around being able to get, if you have a physical disability, you can get basically permission from the board to complete all of your CE through distance learning. That language was removed in our comprehensive proposal now that they're going to have the on-demand, Zoom type conferences that they can, participate in remotely. So it removes that need. I would say, I think, the staff response to something like that, if it's over 180 days, maybe you may need to consider an inactive license, because I would question, if you can't complete the CE within that time frame, especially with opening up that remote option, how are you practicing? So that was the rationale behind the 180 days. We thought it was reasonable enough. It gives you a whole half of another renewal cycle to get it done. But chronic conditions that go beyond that, if you can't complete your CE, that kind of goes to the whole purpose of requiring you need to do CE with an active license. So that was kind of our counter to that if it was to come up.
Yeah, good point. Good point. Thank you.
Is there any further discussion? Ms. Walker, are we okay with what's gone back to staff for this agenda item?
Yes, yeah, we have sufficient direction. So we'll develop this a little bit further and then plan to bring it back at the next CE committee meeting for a more concrete discussion around proposal.
Okay. Moderator, can we open agenda item number 5 for public comment?
This is the moderator, and at the direction of the committee, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please. Thank you. Okay, moving to agenda item number 6, public comment for items not on the agenda. Moderator, can we please open it up for public comment for items not on the agenda?
All right, this is the moderator, and at the direction of the committee, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment for items not on the agenda, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. All right, it looks like we request from Shasta Carey. And Shasta, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
You guys can hear me.
You're a little quiet. Is it possible that you could get closer to your microphone?
Yeah, definitely. Is that a little better?
Yes, much better. Thank you.
Okay, perfect. So I was just wondering in regards to the live stream Zoom, in order to get, the live hours for people that are unable to attend in person, when are we thinking for that specifically to be implemented?
Ms. Walker, is that?
Sure. Yeah, I was waiting to make sure that was the end of her comment. Yeah, the target implementation date for being able to offer the live Zoom classes as live hours, not distance learning, we're targeting January 1 of 2025.
Got it. Great. Thank you so much.
Thank you for your comment. Thank you for being on the call.
All right, this is a moderator. We have a call-in user. And for our call-in user, I'm going to request to unmute your microphone. You'll be given 3 minutes to speak and a 15-second warning. I believe it's going to be *6 on your device when it asks you to unmute.
Salud, this is Salkin, student intern from Life Chiropractic College West. Just wanted to know that, so I'm an intern at the clinic at Life West, and I inquired about, there's a school at Northwestern University of Health Sciences in Minnesota for their student interns. There's a fundamental difference between the two intern clinics. And I think LifeWest is perfectly legal to operate how they do it, but I think it's significant to note is that for interns at LifeWest, it's designed for interns to recruit their own patients, to bring in their own patients. At Northwestern University of Health Sciences, interns are not required to recruit their own patients. The Northwestern has already a base of established patients for interns to build their clinical experience to graduate. LifeWest doesn't provide that. LifeWest has the interns recruit. And that there's nothing wrong with that, but that's hard, especially for students abroad who like federal students like me who don't have access to a private network that could bring like their private family or their private network to the school for easy recruitment. It's like no one knows me in the local area, so it's like there's like almost a de facto like boycott on visitors if you're not local. But that's not a problem in Northwestern. I don't know if that I guess LifeWest is perfectly legal to do that, but it seems like that should that standard be improved? If we're trying to improve increase the number of chiropractors in California, it seems like I know that LifeWest is moving soon. I don't know where Life is moving after they change campuses, but it seems like that model of interns needing to recruit their own patients should be adjusted because had I not inquired with Northwestern, I had been told prior to this that it was always the expectation for students to find their own patients, and I didn't know that.
15 seconds.
I didn't know that there was another clinic that already had established patients ready for interns without the need to recruit. Thank you.
Thank you for your comments. Appreciate that.
All right, this is the moderator. Appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please. Thank you. Okay, moving to agenda item number 7, future agenda items. And again, I would just remind the public that you may submit proposed agenda items for a future meeting, but we may not discuss or take action on these any proposed matter except to decide whether to place it on the agenda of a future meeting. I would open this up to our board members on the call, the committee. Any future agenda items?
Yeah, I was hoping to put on the agenda the discussion of the renewing of inactive license and the amount of CEs that they need to go from inactive to active. Currently, my understanding as it stands that it's only, well, not only, but it's a year, regardless if they've been out for 5, 6, 7, 8, 10 years. So I'd like to move that to the agenda and have a conversation about that.
Will do. Thank you. It will be a good discussion. Any other future agenda items? Hearing none from the board members. Moderator, can we open this up for public comment?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. It looks like we have a request from Dr. Audrey Egan. And Dr. Egan, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hello?
Hello, we can hear you.
Okay, good. I wanted to circle back to the agenda from January 2023. It looked like item 4 was the discussion that you guys had a really good long discussion regarding continuing education requirements, and it's been like 8 or 12 months, and I see that it's not going to be brought before. It's not going to. You guys are not discussing adding it into our requirements until January 2025, and I'm just asking if you guys could put a little gas under your feet on that one. We've personally, it does affect me. I live in Mexico now, and it's, you know, really hard to get out of the country to get up and do my relicensing. I'm really interested in keeping my California license going, and really enjoy the Zoom classes that we were able to do remotely. So please keep that in mind, that there's a lot of us interested in that, and that's all I have to say.
Thank you, Dr. Egan. I think your comments probably represent a number of DCs out there, and appreciate you being on the call.
All right, this is the moderator. It appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please. Thank you. And I know we do not have to do this, but agenda item number 8, is there a motion to adjourn?
I just want to say thank you to the